Hey, and I'm going to go ahead and get us started back so we stay on schedule today. Alrighty, welcome back everybody. Our next speaker today is Professor Paula Monopoli. Paula Monopoli is a professor of law at the University of Maryland School of Law, where she founded the Women Leadership and Equality Program in 2003. Professor Monopoli received her BA cum laude from Yale College in 1980 and a JD from the University of Virginia School of Law in 1983. She teaches property, trusts, and estates in a seminar in gender in the legal profession. Professor Monopoli has multiple publications in various law journals, as well as 3 books in various estate planning and on various topics in estate planning and gender equality. Professor Monopoli is an elected member of the American Law Institute and an academic fellow of the American College of Trust and Estate Counsel. She held the Outstanding Professor of the Year, She held the Marbury Research Professorship from 2008 to 2011 and has twice been selected as the Outstanding Professor of the Year at the School of Law, most recently in May 2013. Professor Monopoli was also named the University Teacher of the Year at the University of Maryland, Baltimore in 2013. Professor Monopoli's presentation today is entitled, Whither, the Marital Presumption for Inheritance Law After Obergefell. Please join me in welcoming to the stage Paula Monopoli.
Thank you, Ashley. This has just been a fascinating day so far, and I really am delighted to be here in Lubbock, and I wanted to thank Alyssa and Professor Beyer for inviting me to come down today. I've been teaching trust and estates law for almost 25 years, and there have been a few kinds of watershed moments in the field, and one of these obviously is Obergefell, which happened last summer, and we're still we're at the very beginning of thinking about how that's going to play out in a lot of areas, right, that have to do with inheritance law and estate planning. So I have done a lot of work in the area of non-marital children, children who were born out of wedlock. So when the case came down, it began my kind of thought process about what the implications were with regard to not only out of wedlock children, but now shifting into children who were born in wedlock. So today, what I'd like to do with you is to talk about the case and the fact that it requires all states to recognize same-sex marriage, and 3 implications that I see the case having for the traditional marital presumption. The first thing I want to talk about is whether or not state courts are going to extend that presumption to same-sex spouses. I think that's a really fascinating question, and I think it's not clear to us what states are going to do in that regard. Second, I want to talk about how I think that they can do it by focusing on what I call the second prong of the marital presumption, which is the importance of legitimizing children, which has been with us since the marital presumption came into being, rather than the first prong, which is trying to establish some sort of mechanism or surrogate for biological connection between a child and a parent. And the third thing I want to talk about are the differences between the goals of family law, and a lot of these cases have all come up in the family law context, and the goals that we have in estate planning and inheritance law, which I think are very different and may inform how we want to think about whether the marital presumption should be perhaps returned to a conclusive presumption. So I'll talk about those things. And the first thing is whether or not states are going to extend the marital presumption to same-sex spouses after Obergefell. Now, just to remind you, sort of as a primer here, about the marital presumption, historically the marital presumption said that when a child was born to a woman, that we presumed the husband of that woman, if she were married, to be the legal father of that child, the legal parent of that child. That's the historical marital presumption, and it was irrebuttable. For years it was irrebuttable. Now, there's a lot of thoughts about why that was. From a feminist perspective, the argument is that was Lord Mansfield's rule, that husbands didn't want to be embarrassed by allowing someone into court to prove that that child really wasn't the child of the husband, right? Other people have talked about the fact that the irrebuttable nature of it was to give certainty to children who may not actually have been legitimate children, right? But who we wanted to sort of give them the benefits of legitimizing them because there was such a stigma attached to not being a legitimate child. So there's a lot of interesting historical, I think, evidence about the origins of the presumption. So one of the goals was to establish, at least arguably, that there was a biological connection between that husband and that child, and that's the work that the marital presumption did for us. Although when I always talk about this with my colleagues, there's a lot of empirical evidence that shows that in intact marriages, at least 10% of the children are not the biological children of the husband, often unknown to the husband. And my colleagues always, especially my male colleagues, always just sort of look surprised when they hear that statistic. It's a little unsettling, right? But those husbands are the legal parents of those children, given the marital presumption, right? So it's not, yes, it's a surrogate for biology. It was an effort to sort of find whether, there was a biological connection in an era when we didn't have easy genetic testing. But often the presumption conferred parentage on a husband who actually wasn't the biological father. That was how it operated, right? So that was one goal. The second goal, though, was to legitimize children and to give them the benefits of the marriage, to avoid stigma whenever possible. So how does the right to same-sex marriage sort of inform our thinking about whether or not this presumption should be applied not to husbands, but to women who are now going to be spouses of the birth mother, all right? So I began thinking about this by looking at the case itself, by looking at Obergefell and looking at Justice Kennedy's opinion and how he grounded that opinion. So in finding that the due process and the equal protection clauses of the 14th mandated the extension of marriage to same-sex couples, he had 4 different sort of bases for deciding in that regard. But one of those in particular is very interesting. It's the third basis. And the third basis, he talks about how important it is to think about the children of the marriage, right? So he says a third basis for protecting the right to marry is that it safeguards children and families, and it draws meaning from rights of child rearing of the couple, and marriage affords the permanency and stability important to the children's best interest. So part of that case last summer was grounded in how important it was to extend the benefits of marriage to the children of the marriage. The focus was put on the children of the marriage in the decision. So that focus on children and giving them a legitimate parent reinforces marriage, and there have been a lot of people who don't like the decision for that reason because they think that it privileges marriage. It's sort of, and obviously there are other people who don't like it for the substantive outcome of it, but it certainly does kind of emphasize the benefits of marriage and reinforce those. Now, what do we do with the fact that now we have marriage where there's going to be a marriage between 2 women and the non-birth spouse and non-genetic spouse is going to be a woman? Well, there were state courts which were grappling with this problem before Obergefell. So I want to talk about some of those cases and just, again, I'm not going to talk about all the cases, but I want to focus on some of them who grappled with this issue in states that did allow same-sex marriage even before the case last summer. And it's fascinating, and as with, all of law, looking at a variety of courts and looking at how, and I'm going to talk about 3 courts which came down and said we can't extend the marital presumption. It doesn't make sense. It's biologically rooted, and it doesn't make sense to extend it to a woman who's the non-birth spouse. And then there are 3 others that I'm going to talk about which said, of course we're going to extend it. If we have same-sex marriage, the point is to give not just the right to marry, but all the benefits that extend from marriage to that, right? So you've got courts who are, composed of very bright people coming out in exactly opposite directions. And obviously that's sort of the fascinating part for law teaching as we look at these and say, now how do they come out so differently with the similar question? So what have state courts done with this problem? So the first group of cases, these state courts said we can't extend the marital presumption to the same-sex spouse, to the non-birth parent, if you will. And even in those cases, the second 3 that I'm going to talk about, even when courts wanted to get to the result of extending, sometimes they got tripped up in statutory interpretation and precedent. And they sort of had to go to a constitutional analysis. So that's really interesting too, in terms of predicting what states are going to do after Obergefell. So let me quickly highlight the analysis in those first three cases where the courts found that they couldn't extend the marital presumption, even in states that recognize same-sex marriage. Either they recognized it or they gave full faith and credit to another state's same-sex marriage cases. Two of those cases are from New York, and one of them is from Oregon. So the first case was the Pachowski case, which was in New York. And again, a lot of these cases involve divorces. They come up in the family law context. And so, but we have to kind of look at those before we can come back around to estate planning and inheritance to sort of see what the analysis was in these cases, because that's the context in which they tend to arise. So this is a case where the petitioner was the non-birth, non-genetic spouse in a same-sex marriage. And the court in that case focused on the fact that she could not possibly be the biological parent of the child, right? Her spouse had given birth to the child, but she was the non-birth, non-genetic spouse. And when they do that in the case, what the result is that the non-birth spouse is basically treated as though she's a stranger to this child. She's in the same position as a third party coming in and trying to get custody of a child, which is an odd result in and of itself. So the appellate division here found that the lower court properly dismissed the petition and said that the non-birth spouse didn't have standing to come in and ask for custody, and says that the spouse of the birth mother may have standing to seek to displace a parent's right, meaning the birth mother's right to custody, and control of her child, but only upon a showing that the birth mother was basically unfit, that she had neglected the child or was unfit in some other way. And here, the non-birth spouse was not an adoptive parent, was not a biological parent, right? And had basically failed to show any extraordinary circumstances. So the fact that she was married to the birth mother was not an extraordinary circumstance. It didn't give her some additional standing. So it's really interesting because the court says the presumption of legitimacy under the marital presumption is one of biological relationship, not of legal status. And as the non-gestational spouse in a same-sex marriage, there's no possibility that she's the child's biological parent. So again, in the end, it leaves her a stranger to the child, basically, even though there was a marriage. The second case, which was in the New York Family Court, which was QM versus BC, the court made a sort of a similar sort of reasoning in terms of looking at the status of the female couple. But in that case, in many of these cases, the child was the product of artificial insemination with an anonymous sperm donor. But in QM, the couple had been married, they had been separated, the birth mother had had sexual relations with a man outside the marriage, and the child was the product of that relationship, and then the couple got back together, right? So the women are still married when this case comes up, and the father, the alleged putative father, brings an action for paternity. And the two women basically invoke the marital presumption. So the lower court finds the paternity action should be dismissed, and it says it's long been presumed under common law that the child born of a marriage was fathered by the husband, and they talk about the sort of origins of the marital presumption and how it's important to establish the child was legitimate in the eyes of the law, but they also focus on the biological ground behind the marital presumption as well. They distinguish the case that I'm going to talk about in a minute. There's another New York case, GM, where the court found that the marital presumption does apply and did give the non-birth spouse standing, but they distinguished this case because of the circumstances, because there was this male putative father, and that's how the child came into being. And they said if we apply the marital presumption and extend it to the non-birth spouse, that would cut off his rights. So they give significant import to the rights of that putative father, and so they distinguish it. So they say, you know, basically here the respondents seek to rely on the presumption of legitimacy in establishing the non-birth spouse as the second mom, effectively extinguishing the child's right to have a father, which is actually an interesting sort of focus here. Miss C's credible and uncontradicted testimony at the hearing was that she did not have sexual relations with any other man except the putative father during the period of conception. And there was no dispute that the non-birth mom had no biological connection to the child. No one was arguing that she did, obviously. So the rights of the non-biological parents, the two women in the marriage are saying, right, are entitled to the same constitutional protections afforded the biological parents, because under New York's Marriage Equality Act, same-sex marriage was valid. And so they were arguing that the marital presumption should be applied in a gender-neutral way. But the court says, look, even though there's the Marriage Equality Act, same-sex marriage is valid in this state, it doesn't require us to ignore the obvious biological differences between husbands and wives. For instance, the law can as easily be applied to same-sex female married couples, but not to same-sex male couples, neither of whom are able to bear a child. In the same vein, neither spouse in a same-sex female couple can father a child. Thus, while the language of the Marriage Equality Act requires same-sex married couples to be treated the same as all other married couples, it does not preclude differentiation based on essential biology. So they're focused again on the underlying sort of biological implications of the marital presumption, rather than the other sort of goal, I would argue, which was historically to make children legitimate whenever we could, because it reduced the stigma to those children. So the court focused then on whether or not the mom in this case, right, could have the sort of the right to argue in terms of the biology, in terms of the biological presumption, whether there was any sort of room here to extend given the constitutional issues, and they decided that it was perfectly legitimate for them to say no, to differentiate based on biology. So those are the three cases where the state courts looked at this question in the context of same-sex marriage, which was sort of valid. Those are the two cases in New York. And then we switched to a case in Oregon, which was slightly different. The couple in this case, which is Shinovich versus Kemp, the couple in this case had actually gotten married for a brief period of time, and then Oregon had declared their marriage invalid. So they had tried to get married, and they had two children, and they were married at the time the second child was born, but again, the state had eventually declared their marriage invalid. But they were domestic partners, and in Oregon, domestic partners were supposed to get all of the benefits of a married couple. So in the context of, again, a dissolution proceeding here, the non-birth mother, in this case, argues that the failure to extend the marital presumption to her is unconstitutional on that basis, and that the statute affords to married men a privilege, the presumption of being a legal parent of the children of a female spouse, that's not available to the female spouse of a birth mother, right? Because same-sex couples were basically being discriminated against in that context. So they argue that it violated the right to equal privileges and immunities. On the other hand, the birth mother says, well, no, this is again in the context of a divorce. So the birth mother's arguing that her soon-to-be ex-spouse should not have the benefit of the marital presumption. Then the birth mother argues that because there's no dispute that her soon-to-be former spouse is not the biological parent of the child, she argues that the marital presumption should not be extended to her spouse. They agree, the court in Shinovich and Kemp agree with the birth mother, and they basically, again, focus on the presumption and argue that to construe the statute, they're going to look at the legislative history, they're going to talk about what the purposes are, and they really, again, hone in on the language of the statute that talks about establishing paternity. So they say the purpose of the statute is to establish paternity. Paternity means origin or descent from a father, a male parent, right? They cite Webster's dictionary. Even if the gendered aspect of the word is disregarded, paternity refers to a genetic relationship. They sort of go on. And they talk about genetic testing, and the purpose of genetic testing, paternity tests, should be to determine whether or not a particular male is connected to that child. So they continually sort of focus, again, on the biological purpose behind the statute. And when that case was decided in 2009, Oregon actually made the marital presumption, it was still irrebuttable. It was conclusive in the context of this kind of case. One of the interesting things that they hone in on in the statute, and some state statutes have this hook and others don't, is that some marital presumptions which have been codified don't allow even the husband of the birth mother to claim the marital presumption if he were sterile, impotent, or if there was no access to the mother at the time. So the court in Shinovich and Kemp looks at that language and they say, here's another kind of piece of evidence for us that this statute is about biology, right? That if the husband can't claim the marital exemption benefits, the marital presumption benefits, then it's got to be because there's a biological connection here, right? So that, I think, is a very important piece of the analysis in those courts which basically have refused to extend it. So the court concludes here that the birth mother was correct and that her soon-to-be ex-spouse was not going to get the benefit of the marital presumption. And they said even if marital status and gender were taken out of this statute, the statute's not going to apply to her, right? Because she's not entitled to a declaration of legal parentage because there's no biological connection. And this is all about genetics and biological connection. So those are the state court, those are examples of the state courts which have refused to extend the marital presumption to a same-sex spouse. The other group of cases, these other three cases, are cases where there are three courts which, again, faced with very similar factual circumstances in states which recognize same-sex marriage, came out exactly the opposite way. So, for example, there's one in Connecticut, there's one in New York, and then there's a really, I think, very instructive one in Iowa, which I'm going to talk about. So in Connecticut, in Bars versus Pasternak, again, you've got a divorce, you've got a dissolution of marriage action, which the spouses are seeking custody. In this case, the trial court gives custody to the non-birth mother, which is kind of interesting. And after a number of procedural appeals, it goes all the way up to the Connecticut Supreme Court, it comes all the way back down. And the court says, again, that the marital presumption is well-founded in Connecticut law, it's well-founded in common law, it's an ancient principle in terms of how we determine who's a parent. And they talk about the phrases presumption of legitimacy and marital presumption because, again, these particular cases come up in a variety of procedural postures, but they talk about the fact that the marital presumption and the presumption of legitimacy are basically two sides of the same coin. If you decide that a child is a child of the marriage, by implication that means that those are the parties to the marriage are the parents of that child. So the case in Bars, the court looks to the Connecticut case, which was Kerrigan, which had approved same-sex marriage prior to this case coming up. And they look at Kerrigan and they focus again. They're looking not at the biological groundings and underpinnings of the presumption, they're looking at the case decision in Kerrigan, which validated same-sex marriage. And they say, look, in Kerrigan, the Supreme Court in our state finds that same-sex couples can't be denied the constitutional right to marry. And in looking at that, they looked at the economic and the sociological implications of granting same-sex marriage. And they focused in Kerrigan, which was the Connecticut Supreme Court case, much like Obergefell, on the positive sociological and practical benefits to children of allowing same-sex marriage, of conferring the benefits of marriage onto the children. They look at the fact that the Supreme Court in Connecticut had said, the ban on same-sex marriage is likely to have an especially deleterious effect on the children of the marriage. A primary reason why many same-sex couples wish to marry is so that their children can feel secure in knowing that their parents' relationships are as valid and valued as the marital relationships of their friends' parents. So excluding same-sex couples from civil marriage is not going to make the children of opposite-sex marriages any more secure, but it will make the children of same-sex marriages less secure. So again, you've got to focus. The court just chose to focus in a different direction, right? So the three courts that refused to extend the presumption to the female spouse who's the non-birth spouse were focused over here on biology. And then you've got this court in Connecticut focused in the opposite direction on the benefits of same-sex marriage and the legitimization, if you will, of children of same-sex couples. And the court goes on to find that under the case in their state, Kerrigan, which allowed same-sex marriage, it has to extend the presumption. It's mandated, it's mandatory that it extend the presumption if it's to be in keeping with the Supreme Court's decision in that state, which validated same-sex marriage in the first place. So after finding that the presumption applied, then there's a lot of other issues which flow from that. If you say, as the court, that the presumption is going to apply to female spouses, you've got an issue about rebutting the presumption, because today, in most states, the marital presumption, unlike historically, is rebuttable. Well, how do you typically rebut the marital presumption in this day and age? You provide genetic testing to show, right, that the husband is not the father of the child. So there's a whole process by which you can rebut the presumption. Well, obviously, in a same-sex couple where the female is the non-birth spouse, there's not going to be any way that she's going to be able to sustain, right, that sort of rebutting of the marital presumption. So the court then sort of focuses on a different aspect of going forward in the future. If you extend the marital presumption to female same-sex spouses, you've got to sort of move away from the notion of rebutting with DNA testing. And so what are you thinking about? If you retain the fact that the presumption is rebuttable, how would you rebut the marital presumption? You'd rebut it basically by showing that the spouse did not consent. So if the non-birth spouse is contesting the fact, perhaps the birth spouse went and got artificial insemination and had a child, and the non-birth spouse had not consented, that would be a way to rebut the marital presumption. So they begin to shift the ground in terms of thinking about, if we extend, we have to also begin to reshape the implications and the corollary doctrines that go with the marital presumption, which is a really interesting sort of move on the part of the court. Now, as you may remember, in the marital presumption, for example, if a husband is married to a wife and she gives birth, and a man outside the marriage comes in and tries to attack his parentage, the husband gets the benefit of the marital presumption, right? And the outside party is trying to sort of assert that he's really the father. Courts, even though it's a rebuttable presumption, courts are very reluctant to allow evidence like that in, because they are deeply concerned about the intact nature of that marriage, right? So one of the other sort of rationales for the marital presumption is the fact that courts throw up roadblocks to even sort of non-husbands who are trying to establish paternity, right? They don't just let them walk in and put in DNA evidence. In various states, there are various different kinds of procedural thresholds. So in some states like Massachusetts, you have to have a substantial relationship with the child. If you're the guy outside the marriage who's trying to sort of come in and assert that the husband's not the father. And there are similar sorts of procedural roadblocks throughout, because again, they want to really make it difficult to disrupt an intact marriage. So, and I think we sort of, we lose sight of that fact when we think about what are the purposes of the marital presumption. It's to protect intact families from intrusion. And it's, even if the man outside can establish that he's the genetic father of that child, courts still retain the equitable power to keep the husband as the legal parent if they find that it's in the child's best interests. So even if the marital presumption is rebutted, a court can actually decide that the spouse, the husband, in the cases that we've had up to date, can still retain legal parentage because he's got a good relationship with that child thinks that's her father, right, for whatever the reasons are for the best interest. So I think it's really important to remember that courts can declare non-parent husbands as legal fathers, and they've done it quite frequently in the past with regard to the marital presumption. So that the Bars Court finds that the non-birth spouse is in fact the parent under the marital presumption and extends it. The other case that I sort of mentioned previously when I was talking about the New York cases which refused to extend the presumption, there is a New York case where they agreed to extend the presumption, and that's the GM case. So this is the case, a case where the child was conceived, again, using artificial insemination and an anonymous sperm donor, which is slightly different than the prior case. And in the GM case, the court addresses how the marital presumption is going to apply to same-sex couples. And again, they talk about the consent issue. They want to extend the marital presumption to the same-sex spouse. They say under the Marriage Equality Act, we should do this. This is the import of the Marriage Equality Act in New York. But we have the issue about how you deal with the fact that the presumption is rebuttable. And historically, it was done by DNA evidence or rebutting it with some sort of evidence of access, or today in genetic testing. So when they extend the marital presumption, they say in response to the presumption, the birth mother argues that if a biological stranger were presumed to be a parent, the potential exists for a birth mother to have artificial insemination, not tell her spouse, right? And the court says that's always been the case. If the presumption's rebuttable, we're going to come up with a way to allow the female spouse to be able to rebut it. So, for example, the birth mother could produce evidence that she didn't intend her spouse to be the parent of the child, or the non-birth spouse could be faced with a presumption of consent to parenthood, but would have the chance to rebut it by showing that she didn't give her consent. So the fact that it's a rebuttable presumption and that it's historically been done through showing that the father is not somehow genetically connected is not enough of a concern for this court to stop extending the marital presumption to the same-sex spouse. They get by that roadblock, they get over that sort of stumbling block, which is interesting, and extend the presumption to the parent. Now, the third case in this group of cases where you've got a court that's willing to extend the marital presumption to the same-sex non-birth spouse is the Gartner case in Iowa. So this is the Iowa Supreme Court. And again, a couple of years before this case came up, Iowa had approved same-sex marriage in a case called Varnum. So the Iowa Supreme Court in Gartner is faced with two parents, two mothers who are presumed mother and a birth mother, who want the second spouse's name on the birth certificate. And the Department of Vital Statistics has denied them the ability to do that. And they're married when the child is born. The marital presumption exists in Iowa. They say, look, we are the non-birth spouse is the presumed parent, or her name should be on the birth certificate, and the department says no. So the litigation ensues, and the district court decides to say, yes, the marital presumption extends to the non-birth spouse. That's what we're going to find. And it goes up on appeal, the department appeals. And what's fascinating about it is that the Iowa Supreme Court takes up the case and says, well, you know what? The result in the district court case was correct, but they got there the wrong way. So what they did was they looked at the statute and they extended it to the non-birth spouse. But what they failed to sort of grapple with, says the Supreme Court in Iowa, is the fact that we have a whole precedential history about statutory interpretation. And we have rules about statutes which contain masculine language, statutes which contain feminine language, and statutes which contain both. And the district court ignored that. And so they go through this very interesting analysis about whether or not they can do by statutory interpretation what they obviously want to do, which is to extend the marital presumption to the non-birth spouse. And they decide that they can't do it that way. They can't get there that way. And the reason they can't get there that way is because the rules about statutory interpretation in Iowa say, look, yes, if you just have masculine language, you can extend it to women, right? If you just have feminine language, however, that doesn't apply. So they cite an old case where the statute talked about widows, and they said, well, men couldn't come in under the statute because widows meant only females, right? And men couldn't come in and avail themselves of these were pension benefits at the time. So the court then looks at the third category, which is when you have masculine and feminine language, and says, you know what? If we interpret this to extend to women, the statute which talks about husbands and fathers, we're going to be violating our own sort of precedential history, because when we look at statutory interpretation, the cases instruct us when we have masculine and feminine language, the cases say you've basically got to abide by what the legislature clearly intended, which was it meant to sort of have a meaning to that fact that you had masculine and feminine language. When it talks about mothers and fathers or husbands and wives, it has a specific meaning. So we can't just decide to gender neutralize this statute, this marital presumption. But it doesn't stop there. It then says what we're going to do is go to a constitutional analysis. And so under the constitutional analysis, what the court does is say, well, we had a case, Varnum, which said same-sex marriage is valid in Iowa. It clearly, the meaning of that was to extend all the benefits of marriage to same-sex couples, not just the right to marry, but the benefits. There's an equal protection argument under the state constitution that they invoke. And so what they say is that there's absolutely no substantial relationship or reason why the department's arguable rationale for keeping the second spouse off the birth certificate has any connection, right, to the sort of purpose of the legislation of keeping vital statistics, and that same-sex couples need the same sort of documents, birth certificates, as opposite-sex couples. And so they basically dismissed the department's rationale and decided on constitutional grounds so that the second spouse gets the benefit of the marital presumption and is the legal parent of that child from birth. So that's a very interesting case because I think it really gives us a way forward. If we're thinking about how to get to the result, how a court can get to the result with these stumbling blocks, and there are stumbling blocks. And statutory interpretation and gender-neutralizing language in statutes is not as easy as it appears, I think, at first blush. So that's sort of the case law that lays out what states have done in the area of whether they've extended or not extended the marital presumption to same-sex spouses. So how can courts get there? They may run into roadblocks like the statutory interpretation roadblocks that the court in Gartner had. They may run into problems in terms of focusing exclusively on the biology underpinning the traditional marital presumption. And again, what I want to point out is it wasn't just the effort to find a biological connection. In a lot of cases, the husband really wasn't the biological parent, and they still made him the legal parent. It's also the focus on legitimizing children. So if courts begin to focus more on that part of the traditional marital presumption, I think they can reconcile a lot of the difficulty that they have in extending the statute if they can get by the statutory interpretation problems with gender neutralizing the language. And I think we need to begin to shift the premise away from the biology to presumed consent. So we need to begin to reimagine or reconceptualize the marital presumption, if we keep it, as something which is grounded in presumed consent, not biology. So for example, the argument becomes when a couple gets married, opposite sex or same sex, we presume that that couple wants to be the parents of children which are born to that marriage, right? There's a presumed consent argument that comes with signing the marriage certificate and going through the ceremony. That's a very common presumption, right, for all of us, and, in terms of conferring Social Security benefits on someone, if you marry them, we think you want to give them inheritance rights, right? It's not a strange argument to us. The same rationale should apply to the marital presumption, it seems to me, in terms of presumed consent. When you get married, you consent to children that are born to be the parent of children that are born into that marriage or that come into that marriage in that way, right, through some sort of birth process on the part of one of the spouses. That then is easier to reconcile, I think, for courts than the biology, trying to sort of find a biological connection, because obviously in same-sex marriages like this, there is not going to be a biological connection. So unless Kennedy and Obergefell didn't mean anything by extending the benefits of marriage to children, I think we're basically, we've got to sort of figure out how to shift the underlying presumption here, the underlying conceptual basis for the marital presumption if we're going to retain it. The third thing I wanted to sort of say is, from the perspective of inheritance law, family law goals about who's a parent are very different than our goals in estate planning and inheritance law. In family law, it's the parent who's trying to be declared the parent, right? The issue is who's going to be the best person to take care of this child for the child's lifetime. In our area, in inheritance law, that's not the issue. It's usually the child who's trying to claim the parent so that they're eligible to inherit from them. And the child is often grown up. It's not about who's going to be the best person to take care of this child. So for our purposes, if we retain the marital presumption and make the shift that I just talked about, in family law, it makes sense to have that presumption be rebuttable, because you could have someone who is declared a parent who didn't consent. So you need to leave room as a rebuttable presumption to show perhaps that you didn't consent if you're the second spouse, right? But in inheritance law, I think it makes sense to go back to the old irrebuttable presumption or conclusive presumption, because all we're talking about for inheritance law is allocating assets, right? We need finality. We need orderly administration of estates. Those are our goals in figuring out whether or not there's a parent-child connection. We just need to gather the assets and get them dispensed with as quickly as possible. So if we're going to retain the marital presumption and extend it to same-sex spouses, I would suggest to you that we might want to think in our area, in inheritance law, about distinguishing the application of the presumption from how it applies in family law, and consider whether or not we should make it irrebuttable again and conclusive, because I think that's going to help us in a profound way in grappling with certainty, predictability, closing the estate, making sure we have a decision, right, in terms of whether or not that child is eligible to inherit from that parent. So with that, I want to say thank you for your attention, and it's just, again, been a delight to be here.
Okay, thank you so much, Paula Monopoli. Our 10th speaker of today is Dr. Russell James. Dr. James serves as professor and CH Foundation Chair in Personal Financial Planning here in Lubbock at Texas Tech University. He also teaches as an adjunct professor here at the law school on charitable gift planning. Dr. James attended the University of Missouri, where he earned a bachelor's degree in economics as well as a PhD in consumer and family economics. He also received his JD from the University of Missouri School of Law. Dr. James was named 2012 Teacher of the Year by the Personal Financial Planning Student Association and has served on the Texas Tech Neuroimaging Institute Advisory Committee for 4 of the last 5 years. Dr. James has over 100 academic journal and conference publications on charitable giving, neuroeconomics, and other various topics, including his article entitled The New Statistics of Estate Planning, Lifetime and Post-Mortem Wills, Trusts, and Charitable Planning, which is featured in Volume 8, Book 1 of the EPJ that you all received today. His presentation today is titled Wills That Won't. Please join me in welcoming Dr. Russell James.
Well, thanks so much. I'm looking forward to sharing some results that, as an estate planning attorney, are actually pretty interesting results because they're starting to give us answers to some questions that we actually haven't been able to answer before. And that is that we've got information from a new source, a source that we've not been able to, that allows us to answer questions that we've not been able to answer before. So let me explain a little bit about what is so different about this new source of information. Now before, if we wanted to know about people's estate planning behavior from a nationally representative perspective, we had a couple of sources of data. There were post-mortem data for the largest estates. That, of course, comes from the IRS. We have a limited amount of information from there. And, of course, the amount of information is getting smaller and smaller as the exemption has increased. And we have a year in the data there where the estate tax was not mandatory, so that sort of messes up the data involving that year. And, of course, there would occasionally be a study of probate records in a single county or maybe a couple of counties. And then there may be some cases where somebody would do a brief set of surveys to find out where people were right now. That's entirely different than the new set of information. In this new set of information, we're actually able to see the entire lifetime movie. That is, this is information that tracks people from their 50s year after year all the way to the point of death, and even post-mortem tracks where their assets went to. And so it's very exciting to be able to see this source of information where we can actually have confidence in understanding what's taking place on a nationally representative basis. This is part of a large federally funded longitudinal, in-person, well-compensated, nationally representative study on health and retirement issues. Just to give you an idea of the magnitude of this study, every year that it's conducted, the most recent year when it was conducted, just the participant payments were over $2.5 million. The study itself is part of the largest federal grant in the history of the University of Michigan, and we're interested in it because it just happens to include some estate planning information along the way. So because this study has been nationally representative since 1998, it actually started in 1992 with some smaller age segments, we're able to see some trends to see what's been taking place over the last few years, in particular since 1998. This first trend does not require a doctorate in economics to see what's taking place here. This is the share of the population age 55 and above that have estate planning documents. And as you can see there, since about the year 2000, we've seen some consistent drops in the share of older adults who have estate planning documents. These are substantial and these are consistent. Now, what you have in your material, which at the time was the most recent information we had, has 2014 as projected. A few weeks ago, we actually got that information, and so we can now switch from projected to actual. So this is what we had up to the information that you had, and a few weeks ago, we now have the 2014 data, which shows exactly the same thing we've seen every year since the year 2000, which is a continuing decline in people who have, in the share of older adults who have estate planning documents. So what's the story here? Why do we see this continued decline taking place? Well, I want to tell you a story that I can't prove, but I think it has a lot to do with it. And it starts in Missouri. I graduated from the University of Missouri School of Law, and when I graduated back in 1994, Missouri was the only state in which you could do this transfer on death concept with a deed. Now that's kind of a big deal because before, yeah, you could put TODs on the bank accounts, maybe even the automobile, but it was always the real estate that you couldn't TOD, and that required that you had to go through the will process. But once you can TOD the real estate, we can do non-probate transfers for everything. Now, we're of course not interested in Missouri law in 1994. Of course, I was when I was trying to pass the bar, but we wouldn't be interested today. But what's interesting is not back in 1995. We noticed this in 2000. A couple of other states had picked it up. In 2005, a few more states had picked it up. In 2014, which is our most recent data, and of course, today we would add to that California and Texas that have now both picked it up. We see this expansion of the ability to allow these transfer on death deeds. So all we can say is that it has happened at the same time, that there are fewer and fewer people, that is a smaller and smaller percentage of the older population that has will or trust documents. At the same time, we've seen this expansion, this non-probate transfers revolution. So it may make sense that some people are shifting from these will documents to non-probate transfers. In fact, when we dive into the data a little bit later, I think what we'll see is that the younger section of older adults are shifting from wills to non-probate transfers, and the older section, that is 75 and above, they're shifting from wills more into the trust documents, but they may not have grown up being as familiar with these TOD documents. Now, I mentioned that there is a decline in the use of estate planning documents, will or trust documents, but there are actually two trends taking place there. There is a relatively sharp decline in the use of will documents as the primary estate planning document, and a mild increase in the use of inter vivos trust or funded trust documents. So we do have two offsetting trends, except the downward trend in will document use is so much more than the slight upward trend in living trusts. Now, if you're interested in charitable estate planning, and that's what I teach, and so I'm quite interested in that, we actually have some very positive trends taking place there. This shows among those who actually have documents what share of older adults actually include a charitable component in their estate plan. And you can see here that has been increasing substantially over the years. And we do have some new data on that, and the new data suggests the projection was actually precisely correct, that we continue to see an increase in the share of older adults who have a charitable beneficiary in their estate planning document. And I'll show you in a moment why, not only what explains why that's happening, but why it's going to continue and be even more extreme in the coming years. So actually, if you combine these two trends, we've got a very positive trend that says more people are including charitable beneficiaries among those who have documents, and the negative trend that says a smaller share of older adults have documents. So what happens when you combine this positive trend with this negative trend? Well, what you get is a flat line. So if we look at the share of the older population that has a charitable beneficiary in their will or trust document, we see essentially a flat line. That does not indicate that nothing's happening. It indicates, in fact, we have two offsetting trends. And oh, by the way, we do have the brand new data on that. What's happened to our flat line most recently is it's still a flat line. So much excitement there. Now I want to shift gears a little bit and talk about wills that won't. And specifically, there's an interesting thing that we can now do with the data. We have, this is what's called a longitudinal study, so the same people are answering the questions every 2 years, year after year after year. When a person who's in the study dies, the people who run the survey come back and talk to the heirs and find out where everything was distributed. Or if there are no heirs, then whoever the closest caretaker was to find out what happened. So we're actually able to connect lifetime estate planning with post-mortem transfers. And what's different is that we can see what took place before the final will. So this isn't like a probate record where all you get to see is the final will. You can see all of the changes that were made leading up to the point of death, at least every 2 years, and compare that with what actually happened after death. So one of the things we can do is we can examine those people who in their last survey prior to death indicated that they had a signed and witnessed will. We've had a little over 12,000 individuals who have been in this study who have died. And of those, 7,150 of them died and had said in their last survey prior to death that they had a signed and witnessed will. Well, then we're able to see what actually happened to those will documents, going back and interviewing the heirs afterwards. And what we found was that in 38% of the cases, the wills actually controlled something. So what's taking place here? Is this, in fact, that we've got will destruction taking place? Well, in 17% of the cases, the heirs indicated, well, no, there was no will document. So perhaps the testator intentionally destroyed the will document for the purpose of revocation, or perhaps the heirs located the document and also destroyed it for the purpose of revocation. We're not really sure, but that's only 17% of the documents. What's happening in the bulk of the cases is that the heirs are saying, oh yeah, he had a will. No, we didn't use it. So what's taking place here? Well, the most common reason is that the heirs are saying the estate was otherwise distributed. And that, of course, is our non-probate transfers, joint ownership with the right of survivorship, TOD, POD. In other situations, they're indicating, hey, there just wasn't much of value, so we apparently don't have titled assets of enough value to be worth going through the process. Or they had a trust document, all the assets had already been transferred into the trust, so we didn't use that, and 6% said it's none of your business. What we find at the same time, however, is that funded trusts are much more likely to actually control assets after death. A little over 1,100 people died, and having indicated in their last survey prior to death that they had a funded trust. When the heirs were asked about this, in 76% of the cases, the heirs indicated that the trust was controlling distributions. Now, initially, we could compare that 76 to the 38% of wills that actually control assets, and we could see that difference, but the difference is actually larger, because unlike a will, a trust is a private document, so it may be possible that some of those heirs who say, I don't know anything about a funded trust, maybe they don't know about it because trust being a private document, they weren't notified about it because they're not named in it. So this 76% is more of a floor number indicating the difference between a will document and a trust document in terms of actually controlling assets is probably larger. The cases where they indicated they didn't know about any funded trust, in 10% of the cases, they're saying, well, actually there was a will that controlled everything rather than a trust. And then the other cases of nothing much of value, we've got transfer on death or otherwise divided, or no information, or it's not yet distributed. Let's take a look at race and ethnicity in charitable planning to see, and also in estate planning to see what's taking place there. This shows the trend since 1998 among non-Hispanic white, non-Hispanic black, and Hispanic. This is among those who have estate planning documents. Now, this is a remarkable trend for the fact that these lines are so close together. And why I say that is that if you actually look at the average wealth holding of these groups, they should be further apart. This indicates that the minority groups are relatively more generous when they have estate planning documents, more likely to name a charity. But there is an area of much greater divergence in behavior when it comes to estate planning, and that is the share of older adults who actually have estate planning documents. So if we look at the share of adults 55 and above who have estate planning documents, we see there is a massive gap between non-Hispanic whites and minorities in actually having documents. Of course, the trend is downward. It's downward for all groups, but the gap is remaining relatively the same. So if we wanted to look at what are the share of older adults by race or ethnicity who are including who have a charitable component in an estate plan, we see this massive gap. But that massive gap is not a gap in generosity, it's a gap in planning. There's just a far smaller share of non-Hispanic black and Hispanic who have the planning documents. And that's what's driving this difference. Let's take a look at some trends in the use of funded trusts. I mentioned to you that there is an increase over time since 1998 in the share of the adult 55 and over adult population that have funded trusts. Let's take a look at where this is taking place. And here what we're seeing is the trend in the use of funded trusts by wealth. No surprise here, we would expect that those with more wealth are more likely to have a trust. And in fact, we do see that. And not only do we see that, but that is the category in which most of the growth is taking place. We don't see much growth in the use of trusts among those in the bottom 20% of wealth. It's relatively low and flat. But if we look at those in the top 20% or the next 20%, we're getting relatively steady growth in the share of older adults who have a funded trust document. We can also see that there's a little bit of difference by household type. So we're seeing this increase taking place. The increase is actually driven by married households and single female households. We have a relatively flat line in the use of funded trust by single male households that are age 55 and above. And I have absolutely no idea why, but I'll make up a theory if you want me to. When we look at funded trust by education level, there's a relatively straightforward relationship here. Those with more education are also more likely to have a funded trust, and we see that's been relatively consistent in all of the results since 1998. Growth seems to be happening in most of these categories as well. And again here, when we look at the use of funded trust by race or ethnicity, we see strong growth among non-Hispanic white. We see a relative flatness among non-Hispanic black, and then some trends that are kind of going back and forth among Hispanic. But most of the growth is being driven among the use of funded trusts by non-Hispanic white. Now I want to shift gears here a little bit and talk about something that some of you may not be familiar with. This in the nonprofit space was a big deal some years ago, that in 1998 there was a prediction that was made about the magnitude of charitable gifts through estates that would be transferred to charities. And just to give you a sense of how massive this predicted transfer of wealth to charities was, this black line represents the actual dollars received from charities up to that point of the prediction in 1998. The three red lines represent the high, middle, and low estimates for the average amount that would be received by charities over the next 20 years due to this massive wealth transfer. Well, we're almost all the way through that 20-year period, and here's what happened. We didn't quadruple as the conservative estimate suggested or go up sevenfold as the high-level estimate suggested. Essentially, since the year 2000, transfers to charities through estates have been flat. So what happened to this massive wealth transfer, and why didn't charities benefit from it? What's going on? Well, what's going on actually is not at all a surprise. It's simply a matter of demographics. The first thing you need to know is that wealthy people die old. Now, we knew that and we've known that for some time. What's new from this study is that we've learned that wealthy bequest donors die even older. That is, people who have a charitable component in their estate plan live longer than others of their same wealth category. There's lots of explanations for that. People are more socially engaged, tend to live longer, various other reasons for that. But what that means is, as we look at this chart, we move from left to right. We're moving from the bottom 10% of wealth holders to the top 10% of wealth holders. And of course, as we move to the right, the actual dollars come from those who are at the top 10% of wealth holders. So we're at the right-hand side of the category. We now move to the dotted line, that is people who actually have a charitable component in their estate plan. And we are, and if, as is often the case, the charitable transfer is made at the death of the second spouse, and the second spouse is female, we are now at the top right-hand corner of this chart for the actual age of transfer to charities at death. In other words, we're into the later 80s. Now, when we look at the charitable transfers that have taken place among the over 12,000 decedents who have been in this study, we see similar results. Somewhere, depending upon how you want to count it, somewhere between 70 to 90% of all charitable bequest dollars come from decedents age 80 and above. So if we're interested in when those dollars are transferred to charity, they're transferred in the 80s and older, and substantially in the later 80s. Now, we've heard lots of talk about the baby boom, and sometimes we hear about that talk in the same breath as the coming wealth transfer. Those are two completely different things. What I mean is this. The demographics in the age group that actually transfers wealth to charity has nothing to do with the baby boom. It has everything to do with something that happened before the baby boom, known as the baby bust. And that was during the Depression, where there was a substantial drop in the number of live births in the United States. That substantial drop, those people are people who are now in their 80s. That is the generation of the baby bust. We can see this when we look at the total deaths in the U.S., and from all the way up to right about the point of that great wealth transfer prediction of all this money going to charities that never happened, we see this very consistent upward trend that right about that point, right around the year 2000, flattens out. What's taking place with that flattening out? Well, that's simply the delayed effects of the baby bust. There are fewer people in those age categories because they weren't born back in the Depression, so we have fewer people in those age categories that actually transfer dollars to charity. We can see this perhaps more clearly when we look at the population of the U.S. in 5-year age groups since the year 2000. If we look at, for example, on the left-hand side of that chart, where we see the number of people who are in their early 50s or late 50s or early 60s, what do we see? We see this massive increase in the number of people. That's the baby boom, and we hear lots about that. But notice what's happened since the year 2000 in some of these key age demographics, such as the early 80s and late 70s. What's happened is nothing. We've seen complete flatness, which is exactly what we've seen in charitable bequest receipts from charitable organizations, because these are the older age groups at which these transfers typically take place. Now, we can connect this with the ages at which different kinds of charitable plans tend to take place. In a recent study by BNY Mellon, the most common age for creation of a charitable remainder trust was right around age 70 to 74. Certainly a lot of people did it earlier and a lot of people did it older, but about 70 to 74 is that most common age range. Now, if we take a look at what's happening in the 70 to 74 age category, we're just now starting to get that first edge of population growth. Because, of course, this works like a wave on the ocean, where everything on the left-hand side gradually moves over to the right-hand side. So we should expect, if interest rates start to increase at all, we should expect a substantial increase in the use of charitable remainder trusts, because that population, that peak age of creating those documents, is finally starting to grow after a number of years of stagnation. Similarly, taking out charitable gift annuities tends to peak a bit later at age 75 to 79. The realized age for peak bequests, that only happens much later. Right around age 88 is the peak age for that. However, if you have interest in charitable planning, there is reason to believe that the future is bright. Let me explain why that is by starting with the most powerful indicator that somebody is going to leave an estate gift to charity, and that is childlessness. So this shows among those who have estate planning documents what percentage name a charity as one of the recipients. And if we look at the bottom line, these are all individuals age 55 and above. The bottom line are individuals who have grandchildren. And there we see a tendency right around 7% of those folks among those who have documents will include a charity. If they do not have grandchildren, but they do have grandchildren, we see about 11 to 12% of those individuals are including that component in their estate plan. The two top lines, those are childless individuals. So childless individuals, the top red line, who are married, we're seeing very close to 50% of childless married individuals age 55 and above who include a charitable component in their estate plan. It is a massive indicator of the likelihood of naming charity. What does that tell us about what's going to be happening in the upcoming years? Well, one of the things we know about this coming population boom in these older ages is not just there going to be more of them, but they're actually going to be different. And one of the ways in which they're going to be different is they are far more likely to be childless. If we look at the relatively flat childlessness rates, these are individuals who are in their early 80s, late 70s, mid-70s, early 70s. We have that flat rate right around 10% childlessness rate when the census measures it at age 40 to 45. But from that age on, we get this steady, consistent increase in the childlessness rates. So what this is telling us is this coming population boom is not just going to be bigger, which is good for folks who are in estate planning, because estate planning tends to be more active once you get past age 55, but they're more likely to include a charitable component in those plans because they're more likely to be childless. It is also the case that the higher the level of a person's education, the more likely they are to include a charitable component in that estate plan, and that's been a consistent result since the study started. We also know something else about this coming population boom in these older ages. There won't just be more people, those people will be more highly educated. So once again, another driving factor indicates that we're going to see an increase in the amount of charitable estate planning. And finally, there is, unsurprisingly, a relationship between people's current giving and volunteering and their tendency to have a charitable component in their estate plan among those who have documents. Those who neither give or volunteer, where giving is defined as at least $500 a year to charity, around 4% of those individuals are including a gift to charity in their estate plans. For people who either volunteer or donate, somewhere around 9% of those individuals are including a gift. And for those who both give and volunteer, we double that to about 18% who are including a charitable component in their estate plans. Now, that's also promising for the future, because if we look at both giving and volunteering trends among the 55 and over population, we see positive trends taking place there. So, different verse, same song. We're going to have a older population that is not only going to be larger, but they're going to be different, and they're going to be different in ways that all push towards more charitable components in estate planning documents. So let's shift gears now a little bit and ask, who are these people who tend to engage in charitable estate planning? So first what we want to do is to predict who actually left a charitable estate gift at death. So we're looking only at individuals who have died and trying to go back and say what were the lifetime indicators that that person was going to leave a gift to charity at death. And the way we rank the indicators is number one, how powerful is it? And number two, how many people does it apply to? And so when we look at our top 10 lifetime predictors of a post-mortem bequest gift, when we look at the top 10, number one is consistency in being a donor. Not a surprise. People who are consistent in being a charitable, giving more than $500 a year to charity are more likely to include charity in their estate plans. And so this is the percentage of years they were in the survey indicating that they made those gifts. The second factor is no offspring. It's individually more powerful than the first, but it only applies to a relatively small share of the population. The third most important factor was what was the largest gift they ever made while they were in the survey. And the fourth might have been a bit of a surprise until we'd seen the earlier results, and that is their consistency in reporting having a funded trust. And the big factor here is that there's a lot of people who are quite charitable, and they may in fact have a charity named in the will, and that will controls assets in only 38% of the cases, so they don't actually make any transfers to charity after death. Whereas if they have a funded trust, they're much more likely to have that document actually controlling the assets. And so that was a major factor in whether they actually transferred any money to charity at death. Women were a bit more likely than men to transfer dollars to charity at death. The sixth most important factor was how much money they died with. That is their last reported wealth prior to death. Seventh most important factor is that they're not married. This is because typically you often get married spouses who will leave everything to the surviving spouse. Eighth is their last reported giving. So we not only want them to be consistent donors, and we would like for them to give all the way up to the point of death. So this is their giving in their last survey prior to death. And it's not enough that they're wealthy. We actually want them to be wealthy, and we want that wealth to have been growing wealth. In other words, if you have somebody who dies with $10 million, if a few years before they had $2 million, they're far more likely to include a charitable gift in their estate plan than if a few years ago they had $50 million and they came down to 10. So growing wealth is important. And then finally, consistency in volunteering was also a factor in making that prediction. For those of you who are stat geeks like me, you have maybe this in your information. We won't dive into it. It just says what I said before, but with more specificity. And what about actual dollars that go to charity at death? What are the most important predictors? The most important predictor was how much on average were they giving, were they donating prior to death? How much money did they die with? And did they have any kids? So if they gave a lot, they had a lot, and they had no kids, they're going to leave lots of dollars to charity. Last reported giving, we not only want them to be giving a lot on average, we want them to end with a lot of giving, and once again, consistency with having a funded trust. Highest ever reported wealth, that's a negative factor. The reason that's negative is if we already know their ending wealth, we don't want them to have ended that high ending wealth from a lower trajectory. So we want them to end on a high note. People are more generous when they end on a high note. Average wealth over time is important. Lowest ever reported wealth is a negative as well because we want that positive trend. Skip that for now. Okay, what about this? When do plans change? So specifically what we're looking at, and we're looking at the charitable component here, is what happens at the same time that people either add a charitable component, that is, they didn't have one before and they added one, or they drop a charitable component, that is, they have a charitable component and then they no longer have any charitable component. So let's first look at the top 10 factors that predict when charitable plans are added. That is, the person says, no, I don't have a charitable component. No, I don't have a charitable component. And then the next survey year, they say, yes, now I do have a charitable component. When we look at this top 10 list, we see that most of these categories fall into one of two boxes. Either family structure changes or death becomes real. So the number one most powerful predictor was that they were actually approaching death. And we know that because they're dead now. And that was their last survey they filled out before they died. They may not have known it, but we certainly do know it now. That was a strong indicator that they're going to add a charitable component. Becoming a widow or widower was a strong indicator they're going to add a charitable component. Diagnosis with cancer, decline in self-reported health, divorce, diagnosis with heart problems, stroke, first grandchild, we'll talk about that in a moment, increasing assets, and increasing charitable giving. Now, I want to hold the discussion on that to flip it around now and ask the opposite question. What are the factors that predicted when charitable plans are dropped? Now, this isn't a person switching charity. This is a person who has a charitable component in their estate plan, and then they no longer have a charitable component in their estate plan. So what happens when they drop charity out? Well, if we look at this top 10 list, it should look eerily familiar. We're getting these same indicators of either change in family structure or what I call death becomes real. Number one most powerful indicator. Decline in self-reported health. These aren't people who have always been grumpy. They've said, oh, I'm fine, I'm not so fine. Actually approaching death, it was their final survey they filled out prior to death, becoming a widow or widower, divorce, diagnosis with cancer, heart problems, stroke, birth of a first grandchild, birth of a first child, and then finally exiting home ownership, which often relates to moving into a nursing home, no longer being a homeowner. So what's taking place here? What's taking place here is simply this. Plans destabilize when either death feels near or family structure changes. This is the engine that drives estate planning changes. And the charitable component really is just the caboose on the train. So if you have an estate plan that has a charitable component in it, and one of these things happens, you're more likely to go get new estate planning documents, which means there's a chance that your new estate planning documents won't have that charitable component in them. Conversely, if you don't have a charitable component in your estate plan and one of these things happen, then there's a much larger chance that there is some chance that you're going to have a charitable component that takes place. So both of these factors are essentially driving new planning. The one factor we weren't able to test because it's not in the survey, but we're getting ready to run a new survey to test this, is plans for travel. Because I know when I was in practice, half of the documents I did was somebody was getting ready to take a trip. So that's probably also an indicator of plan changes. Then when we look at the charitable component among those who actually transferred dollars to charity at death, what we see is a lot of end-of-life instability in these plans. Not only from what we saw before, a lot of dropping of charitable components, a lot of adding of charitable components, but now when we look at those who are decedents who actually transfer dollars to charity at death, what we can do is we can go back and look at their lifetime responses to see what was the most recent time they indicated affirmatively that they did not have a charitable component in their estate plan. And that allows us to see how recently did they add that charitable component prior to death. We can't get that from the probate record because the probate record will likely just have their final will, but we don't know when that charitable component was actually added. It may have been added 6 or 7 wills before, but this longitudinal survey allows us to do that. And what we see is that for the majority of states, everything in red are individuals who added that charitable component within the last 5 years of death. Dark red is the last 2 years prior to death. So everything in red are charitable plans that were added within the last 5 years of death. That means within the last 5 years of death, the person affirmatively said, I do not have a charitable component in my estate plan, yet they ultimately ended up transferring dollars to charity. So the majority of estates, and just barely the majority of dollars gifted, come from plans that are added in the last 5 years prior to death. So once again, we're seeing a lot of end-of-life instability in this charitable planning component. It is, of course, the case that people who've had that charitable component for a larger number of years also, on average, transfer more dollars to charity. We also have some new data from Australia. Australia did a really cool study, which we couldn't really do here in the U.S. because we keep probate records at the county level. They keep it at the province level, so it's a lot easier to actually take a full national sample of probate records. But in this sample of probate records from the whole country, they found that 31% of charitable wills were signed within 2 years of death, and 60% of charitable wills were signed within 5 years of death. So we're getting corresponding information from other countries that suggests this is when those decisions tend to be made. All of this information says the same thing. When we look at lifetime reports made as death approaches, or postmortem transfers as compared to lifetime reports, or the timing of the last changes made to the final wills, we see it all says the same thing. Plans destabilize as death approaches, in particular in the last 2 to 5 years prior to death. So another way to take a look at this is to look at the 10-year retention of a charitable estate component. Because this is a longitudinal study, what we do is we take all the people who said in the initial year, yes, I have a charitable component in my estate plan, and we then look at all of them among those who are still answering the question 10 years later, and we say, what percentage of them are still saying, yes, I still have a charitable component in my estate plan? And what we see is a really remarkably consistent result of right around 55% retention rate over a 10-year period for those first, the age group 70 and above, and then later we were able to test the age group from 50 to 69. This shows a charitable plan loss trajectory. Here we're actually looking at individuals who indicated both in 1998 and in the year 2000 that they had a charitable component in their estate plan, and we see each subsequent year among those who are still answering the question, what percentage still say, yes, I've got a charitable component in my estate plan, and we see this drop off that happens over the next several years. These transfers are actually being made at a quite old age. Half of all charitable bequest dollars came from decedents this age and older. It was about age 85 for the U.S. study and about age 90 for the Australian study. Now, actually, for the U.S. study, the age is closer to 88 because that study started back in 1992, and we've had increases in longevity since then. So the Australian study was pretty remarkable when you think that when you get to age 90, you've only gotten half of the dollars from your decedents that you're going to get. Because again, wealthy people die old, wealthy charitable bequest, people with a charitable estate component live even longer. This shows that the age at will signing of those who transferred dollars to charity at death using the Australian data by the share of total charitable bequest dollars transferred. 76% of the dollars actually transferred through wills to charities in Australia were transferred by wills signed in the 80s, 90s, or older. If you're interested in wills signed before age 70, those wills only transferred 13% of the dollars. This is the result of that demographic reality of wealthy people live longer, as do people who have a charitable component. And then this most interesting study from the United Kingdom, which involved a large solicitor firm that does a high volume of estate plans. They do a lot of over-the-phone estate planning documents. And they did an actual experiment working with a couple of professors using 3,000 different folks going through their normal estate planning process. The way the experiment was set up was this. People were randomly assigned, unbeknownst to them, they were randomly assigned to one of three categories. The first group just got the standard estate planning questions. You know, a whole series of normal questions. What do you own? Who's your family? Who do you want it to go to? The second group got the exact same questions, but one extra question. The extra question was, would you like to leave any money to charity in your will? Just asking the question more than doubled the share of people who are including a charitable component in their estate plan. Now, this tells us a couple of things. It tells us, number one, there's lots and lots of things people are trying to think about when they're going through their estate planning process. And if they're not reminded of these possibilities, their behavior is going to be dramatically different. It also suggests there's a fair amount of fluidity in these kinds of choices. When you can more than double the participation rate just by asking the question, there's a lot of fluidity. Beyond that, 1/3, which is another 1,000 individuals, were given the standard estate planning questions plus one extra question that include what we call a social norm statement. Many of our customers like to leave money to charity in their will. That use of a social norm statement now more than tripled the share of people who are actually including a charitable component in their estate plan, suggesting there's a lot of fluidity in these charitable estate planning decisions, which of course is what we see at the end of life, where these components tend to get added and taken out quite easily. So we do see a lot of potential for influence even from a single sentence. I will say that most all of this change was driven by childless individuals, and that they were much more likely to be influenced. Okay, so just a couple of other small component pieces that may be of interest. I mentioned that when death feels near or family structure changes, the plans they're both added and dropped. What is the net effect on charitable components if we weigh out the both adding and dropping? Here are the things that have the most positive net effect on adding a charitable component. After you net out the dropping, if you begin giving, that makes sense. If you begin volunteering, that makes sense. If your wealth goes up a lot more, if you start volunteering a lot more, for some reason being diagnosed with cancer makes you particularly charitable. Not sure why that is, but it does occur. Also increasing the amount of money that you're giving to a charity. Becoming a widow or widower tends to be relatively positive, and approaching death. People become more likely to add than to drop a charitable component. Well, I could take hours and hours for this because I love this sort of thing, but I'm just about out of time here. If you like to take hours and hours with this stuff, there's a wonderful law review article I can recommend to your reading there that may have interest for you. I hope some of this has been of interest today, and thank you so much for listening for these. Thanks.
Before we go on to our next break, we have the raffle drawings that are going to be done right now. I didn't put my card in, so lucky for you all, your chances have increased. After the drawing, we'll take another 10-minute break and then finish with our final two speakers.
All right, so we have the drawing for the $100 gift card. Southwest Bank was nice enough to provide that for us, so I will let her draw a name out. Brian Merkley. Yeah. I think that there's something going on up there. It's at our booth. Okay, it'll be at the booth for you, Brian, whenever you're on your break. And Happy State Bank has been nice enough to provide a lovely poker set for us. So, you want me to do it? How will it look? Myrtle McDonald. Are you here? Okay, well, she forfeits. Nicholas Getchy, are you here? Woo! You won a poker set. All right, it'll be out there when you're ready. Thank you, guys. Be sure to thank our wonderful sponsors for being here, and you get another 10-minute break. We'll see you back in just a little bit.
Okay, we're all trickling back in here. We'll go ahead and get started and introduce our 11th speaker for today, which is Professor Bill LaPiana. Professor LaPiana is the Rita and Joseph Solomon Professor of Wills, Trusts, and Estates, as well as the Director of Estate Planning Studies in the Graduate Tax Program at New York Law School. Professor LaPiana holds both a PhD in history and a JD from Harvard, where he also received his bachelor's and master's degrees. After graduating from Harvard Law School in 1978, Professor LaPiana spent 4 years as an associate at Davis, Polk & Wardwell in New York. Professor LaPiana is the author of several articles on estate planning, numerous articles in American legal history, and has authored several books. He's also been active with the trust and estate sections of both the New York State and the American Bar Associations. In 1992, he was elected as an academic fellow of the American College of Trust and Estate Council and served as a member of the board of directors of ACTEC Foundation for a 3-year term ending in 2015. Professor LaPiana's presentation today is titled Same-Sex Marriage and the Road to Nationwide Recognition. Please join me in welcoming to the stage Bill LaPiana.
Thank you. I've been coming to talk to you about same-sex marriage now for several years, and in that very short period of time, same-sex marriage has gone from something that was a novelty in a handful of states to the law of the land. Now that the Obergefell decision is out there, as of June 26th of last year, same-sex couples must be allowed to marry in every U.S. jurisdiction, which means, of course, all the states and the territories and the various other odd pieces of the American polity. But in addition, states must recognize same-sex marriage as validly entered into. So what we're really going to talk about today is one small aspect of this nationwide growth of same-sex marriage. There are others. Professor Monopoli talked about some of them earlier today. What effects this has on notions of parentage and legal parentage will take a while to work out. There are other, actually quite large constitutional issues that basically fall into two categories. One is, what are the rights of people who don't wish to have anything to do with same-sex marriage? This has basically manifested itself in two ways. One, public officials not wanting to issue marriage licenses to same-sex couples, and purveyors of goods and services who want to be able to refuse to provide those goods and services, generally for same-sex marriage ceremonies and celebrations. These issues implicate very profound issues of our constitutional law because they lie right at the intersection of questions of equal protection and the guarantees of the First Amendment, both for free exercise of religion and the prohibition on the establishment of religion, issues which the courts are going to spend some time, I think, in resolving, far beyond what we're going to talk about today. The other issue is even more far-reaching, or potentially far-reaching, and that is, to what degree has Obergefell resurrected the old and for a time discredited idea of substantive due process? That is, the recognition of rights beyond those actually mentioned in the Constitution, somehow inhering in our society and polity with which the government may not interfere. We thought perhaps this was over with after Lochner was discredited in the 1930s, but lo and behold, perhaps it's not. This is the kind of topic the historian side of me we could talk about forever, but my inner historian is firmly banished from this stage. And I don't dare talk about it as a lawyer, because the last thing any T&E lawyer wants to do is get his colleagues who teach constitutional law riled up, thinking that he is trenching on their sacred territory. So I commend to you, though, the case that's cited on page 3, the Struniak case from the Eastern District of Virginia, decided early this year, which includes a very lucid and learned discussion of the current state of the idea of substantive due process and the effect Obergefell may or may not have on it. So what we're going to do, though, instead of talking about all those things, we're going to jump right to page 14 and talk about what is at the heart of this brief presentation, which is to what degree are the holdings in Obergefell retroactive. Now, the grant of cert in Burke v. Bashir, which became Obergefell, posed two questions. One was, must the states allow same-sex couples to marry? And the answer was clearly yes. And the other question that the advocates were supposed to address before the court was, quote, does the 14th Amendment require a state to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state? That, too, was answered in the affirmative. And it raises the question of when a state must begin to recognize a valid same-sex marriage. Let me give you the hypothetical, which is quite real, frankly. When my spouse and I were getting our marriage license at the New York County Clerk, whose offices are directly across the street from the building in which we live, right on the spot of the 5 points, interestingly enough, there was a same-sex couple from Texas who were getting their marriage license and were going to marry that day, having gotten the permission. There's always a state Supreme Court judge in New York County who sits in chambers solely to grant the permission to not to have the waiting period between the issue of the license and the celebration of the wedding ceremony. They knew that their marriage would not be recognized as soon as they went home to Texas, but they wanted to do this to impress on their families the strength of their commitment with the hope that their relatives then would not challenge their wills. They returned to Texas clearly married, but that raises some questions. Now, as a practical matter, the first marriages within the United States between same-sex couples that are unquestionably valid began, the earliest date is May 17, 2004 in Massachusetts. There is a slight question about whether marriages entered into foreign nations, again, valid where celebrated, would be recognized. This may just be a mistake or a quirk of language in Justice Kennedy's opinion. The actual language from the Obergefell opinion says, it follows, that is from the holding of state which license a marriage between two persons of the same sex, that the court must also hold, and it now does hold, that there is no lawful basis for a state to refuse to recognize a lawful same-sex marriage performed in another state on the ground of its same-sex character. Now, presumably that includes a marriage entered into in a foreign country. In Canada, for instance, one could have married before, for instance, in New York, legally in New York State, obviously easy access to calendar, but whether or not the principle is the same. When did that marriage start? And this is far from a merely academic question. Remember our Texas couple, they come home for Texas, they are living together, they are filing after Windsor joint federal income tax returns. After Obergefell, as is inevitable, one of the spouses dies. When did they start to accumulate community property? From the date of their valid marriage or from the date of Obergefell? June 26, 2015, when Texas had to recognize that marriage. Same question on dissolution by divorce. Here's another wonderful question. On returning to Texas, one of them buys a home, which they live in, but totally with his or her own funds, which would be, however, community funds had Texas recognized the marriage. Before the date of Obergefell, the spouse, who's the only name on that deed, sells the house. After Obergefell, does the buyer have good title? Because maybe that house was community property to begin with. Same in common law title states, where in many, that pool of property subject to the equitable elective share right includes property with which the spouses have done transactions, made gifts, created other estate planning arrangements. Whether or not that property is included in the pool against which the elective share right can be enforced depends on whether or not the transaction occurred during the marriage. Again, when did the marriage begin for those purposes? Certainly in common law title states, conveyances to a couple described as spouses may result in their holding, if not as tenants by the entirety because they're not married, at least as tenants, joint tenants with right of survivorship. If they're described as spouses in the deed before the state recognizes the marriage, what is the state of the title? Their creditors are certainly going to care. In common law title states, which now all have the concept of equitable distribution on divorce, which requires you to designate marital property for the court to figure that out. When did the accumulation of marital property begin? If I have time, there's a very recent New York case on that, which illustrates the problem that arises. Again, as Professor Monopoli told us, whether or not marriage exists is an important factor in determining the parentage of children. And then, of course, states with robust homestead protection, Texas to some degree, but Florida most importantly of all. In Florida, homestead is neither alienable, divisible, nor descendable. I still can't figure that out. I don't understand how feudalism ended up living in Florida. But there are a lot of Florida title guarantee companies a little concerned now about people who conveyed what would have been homestead had Florida recognized the marriage before the date of Obergefell. Well, Florida had to recognize the marriages a few months earlier because of the way their litigation played out. But again, when did that marriage start? Well, and finally, the intestacy statutes of every U.S. jurisdiction make a surviving spouse the principal, if not sole heir of the decedent. So what happens when death comes before Obergefell? The state doesn't recognize the marriage. As far as the state's concerned, the surviving spouse is a stranger. When it comes to property law distribution, what happens perhaps a few months later when Obergefell is decided? How far back do I get to be the heir of my late spouse? Well, there are actually some answers to this. If you take a look at page 17, we have to start with the Supreme Court's own statements on how its decisions are retroactive. And the latest and the definitive statement on this actually is in a case called Harper v. Virginia Department of Taxation, the first case I've really had to read in a long time in which someone didn't die. Virginia levied state income tax on pensions paid by the federal government, but not on pensions paid by the state of Commonwealth of Virginia or its local governmental entities. Michigan had a similar law, and not surprisingly, the United States Supreme Court said it was unconstitutional and a violation of equal protection. So some taxpayers in Virginia who are receiving federal pensions sued the Commonwealth and said, we want our money back. It's an inordinately complicated case. It goes up and down, up to the Supreme Court once, down to the Virginia courts, up again. But the important thing is in the decision that was rendered in 1993, the opinion says this: when this court applies a rule of federal law to the parties before it, that rule is the controlling interpretation of federal law and must be given full retroactive effect in all cases, still open on direct review and as to all events, regardless of whether such events predate or postdate our announcement of the rule. Now, it's no coincidence that the author of this opinion is Justice Thomas. He and the late Justice Scalia were adamant that every decision of the courts is retroactive because the only legitimate maker of purely prospective law in our system is the legislature. But be that as it may, this was a unanimous decision of the United States Supreme Court, and it gets fleshed out in 1995 in an opinion in a case called Reynoldsville Casket Company v. Hyde. This starts out with a road accident in Ohio. And Hyde, an Ohio resident, is injured. It involves a truck owned by an out-of-state company, clearly Reynoldsville Casket Company. Yeah, I know, nobody died, but it's a casket company, so this was meant to be that I'd have to deal with this. So she brings her action after the running of the 2-year Ohio statute of limitations, but under a provision of Ohio law that tolls the statute when the person against whom the cause of action accrues is out of state. While Ms. Hyde's action is pending, the United States Supreme Court strikes down the Ohio statute as, of all things, a violation of the Commerce Clause. That's the Bendix case. Well, The Ohio Trial Court, the Intermediate Appellate Court, dismissed the Hyde case after the decision of the United States Supreme Court, but the Ohio State Supreme Court reinstates it. The defendant appeals to the United States Supreme Court in an opinion by Justice Breyer, writing for 6 justices, and there are a couple of concurring opinions. It's one of those awful Supreme Court things where to find the holding you actually have to use a Ouija board, but it's actually pretty simple. What it comes down to is that Justice Breyer says our decision is retroactive. Now, that retroactivity can be limited in some circumstances. There will be instances where the new rule, for what he calls well-established legal reasons, does not determine the outcome of the current case. That could be where an alternative way of curing the constitutional violation exists, a previously existing independent legal basis having nothing to do with retroactivity for denying relief. Keep that one in mind because that's the important one. As in the rule of qualified immunity, a well-established general legal rule that trumps the new rule of law, which reflects both reliance interests and other significant policy justifications. That's another one to keep in mind. And then a principle of law that has to do with finality that's very much involved in criminal law cases. Reynoldsville then gives several possibilities for arguing to limit the retroactive effect of Obergefell, at least in some situations. One of those exactly is exemplified, although the case opinion doesn't talk about either Harper or Reynoldsville, is a case called Horvath v. Dodaro, which is on the bottom of page 19, decided in the U.S. District Court for the District of Columbia late in 2015. The plaintiff is a federal employee who married his same-sex partner in Massachusetts very early, almost as soon as it could be done, applied for health insurance benefits for his partner, was of course denied because of DOMA, reapplied after Windsor, of course then the benefits came through, and then is now suing for compensation for the lost benefits between the period of their marriage to the decision of the Windsor case. The case is dismissed, but basically because the statutes of limitations have run out. Not that anything was or wasn't retroactive, but that there seems to be one of those independent bases for denying relief. In this instance, the statute of limitations is gone. Another very recent example of this on page 20, Schuett v. FedEx. This one does make direct reference to Harper and Reynoldsville. We have a same-sex couple in California. One of the partners, they marry quite late in this relationship, one of the partners works for FedEx for many, many years, is fully vested in all her pension rights. She becomes ill as her condition deteriorates. She and her partner contact FedEx Human Resources, and they are told, the ill employee is told, make your partner, by this time they are California registered domestic partners, the beneficiary of your 401k, of your life insurance. But as far as your pension plan goes, this isn't going to work because our pension plan defines spouse, who is the default beneficiary, as spouse determined under federal law, which includes, of course, DOMA. And it directly references DOMA. The couple marry on the literally why the ill partner is on her deathbed. Marriage performed by a properly licensed California magistrate a few days before the Windsor decision, which also was the time that the Supreme Court refused to hear any more argument in Carey v. Schwarzenegger, which left the lower California federal court's decisions that Proposition 8, which undid same-sex marriage in California, was unconstitutional, and the Supreme Court refused to hear any more argument because the people attacking that decision lacked standing. The surviving spouse now, over the next few months, carries on a California proceeding to have their marriage retroactively declared valid, which can be done, and by September of 2013, she obtains what's called a delayed certificate of marriage. She then sues FedEx on 3 grounds for denying the benefit that she wants as the surviving spouse, for failure to administer the claim for benefit in accord with applicable law, and for a violation of fiduciary duties for giving them bad advice. They were seeking advice before her spouse's death. To make a long story short, the federal court concludes that Windsor is clearly retroactive under Harper and Reynoldsville, that DOMA never was, that the pension plan that defines marriage in terms of DOMA can't do that, and then to define it in terms of DOMA actually violates federal law, which the pension plan's own documents say it must be administered in conformity with. Trial will go forward. There was a motion by FedEx to dismiss the complaint. They won on 2 of the counts, but not on that one. So we'll see what happens. But that's the closest we come to some federal statements about what Obergefell actually means going forward. Now, we are not, however, and this is where the historian of me comes back for a brief cameo, we are not perhaps without some guidance from history. And I owe the suggestion of looking at this to Professor Lee Ford Tritt of the University of Florida. And Lee Ford said at one point we were discussing this, we were actually on a panel with one of the lawyers involved in the Schuett case, said, you know, the last time the Supreme Court did something under equal protection that really had a big effect on intestate estate planning was Trimble v. Gordon back in 1997, which held that an Illinois statute that excluding a non-marital child from inheriting from the child's father unless the biological and the mother marry was unconstitutional. So needless to say, lots of non-marital children began to claim their rights as heirs of their biological fathers. And the Supreme Court in '86 dealt with just that claim coming from Texas in a case called Reed v. Campbell. Now, this is to summarize the syllabus of the opinion for you. The father dies intestate when the then Texas probate code prohibited a non-marital child from inheriting from the father unless the parents subsequently married, the exact statute you had in Illinois and invalidated in Trimble. Trimble comes down 4 months after the father's death. The child goes into the Texas courts and basically says, I am my father's heir, at least one of the heirs. And the Texas courts said, no, you're not. Trimble doesn't apply retroactively. And the United States Supreme Court reversed. Opinion by Justice Stevens, the court holds that the child's interest must be protected by the full applicability of Trimble. There's no justification for the state's rejection of the claim. At the time the appellant filed her claim, Trimble had been decided, and her father's estate remained open. Neither the date of the father's death nor the date of the claim was filed should have prevented the applicability of Trimble. Those dates, either separately or in combination, had no impact on the state's interest in orderly administration of the estate. So, Trimble, retroactive to intestacy claims, at least where the estate remains open. Now, this is a perfect example of what the United States Supreme Court always does when it gets involved in trusts and estates. Doesn't do it quite right. What does open mean? How many estates are actually formally closed, if by that you mean the personal representative actually does a judicial accounting and gets a decree releasing the PR from any further liability and saying everything you did was perfectly okay? Probably not many. And it's that problem that the states deal with in some of the cases that follow Trimble. The most interesting way of dealing with this, which I think may provide a path for dealing with the retroactivity of Obergefell, you find, of all places, in Mississippi. On July 1, 1981, a Mississippi statute became law which said that to all those non-marital children whose fathers died before Trimble, you have 3 years to assert your rights in your late father's estate. And then you'll be foreclosed. It's a statute of repose, right? You can The laws change, you got 3 years to get this sorted out, and after that your claim is forever foreclosed. The Mississippi Supreme Court upholds the validity of the law. It is constitutional as far as they're concerned. And in subsequent cases, the Mississippi Supreme Court reverses dismissals of suits brought within the 3-year period of the statute by persons claiming to be the non-marital children of decedents who died in 1977, 1969, and 1958. How could that be? Well, we'll get to that in a minute when I tell you about the Hawaii case. The interesting one, though, is in 1988, the Mississippi Supreme Court decides Collier v. Shell Oil, in which it says, well, yeah, you're within the 3-year period, you are the non-marital child of your late father, but you're not going to get your hands on the land involved because Shell Oil's a bona fide purchaser without notice. Same principle at the bottom, in the middle, page 24, in Kau Agribusiness Inc., the heirs or assigns of Ahulau from Hawaii, 2004. There the claim is coming through the estate of a decedent who died intestate in 1939. And the Hawaii High Court says, the uncle's estate was never probated, and therefore concerns of finality are not at issue. Now again, we have bona fide purchasers, that's why the claim doesn't work. And in addition, the parentage is not sufficiently proven. But the interesting thing here is the estate was never probated, concerns of finality are not at issue. It's no surprise that these cases all involve real property, because we all know that ultimately, because the Normans conquered England, we still have this crazy idea that real estate somehow passes at the instant of death, even though it passes under a will that has yet to be probated, or you still have an opened administration. There are surrogates courts in the state of New York that will not open an intestate administration where the only probate asset is real estate, because the court is adamant it passed at the instant of death, just put an affidavit in the death certificate into the land records. The reason these cases can exist is that idea, and of course, the simple fact that the land doesn't go away. I did a version of this for my colleagues a couple of weeks ago, and one of the questions is, but what happened to all the personal property? I said, well, the principle is the same, but you go try to get your hands and trace personal property from the estate of a decedent who died intestate in 1939. It's not going to work. It's going to be all about land. But what I think this all shows us is that the retroactivity is real, but a lot of common sense application of well-known legal doctrines prevents what we could call, massive inconvenience, or at least confusion, especially in land titles. There are lots of state cases after Trimble's state Supreme Court cases dealing with its retroactivity and validation of their state statutes. To make a very long story short, there's a lot of discussion on this on pages 25 and 26. But to condense it, you got to be careful with this, because at the time these cases were decided, the United States Supreme Court's own retroactivity jurisprudence was not as clear as it is after Harper and Reynoldsville. To make a long story short, there was a Chevron case, Chevron regulation, the different Chevron case, under which the Supreme Court had concocted an inordinately complex balancing test for the degree to which its decisions were retroactive. Harper represents a complete rejection of that as unusable. So why the cases that grow out of Trimble v. Gordon are certainly interesting and suggestive, the way the states treated it, they're not determinative. And in addition, I think it's much clearer today than it was even a generation ago, that when the Supreme Court says the Equal Protection Clause requires this, and this is, among other things, the destruction of your state statute and maybe even provisions of your state constitution, whether or not that's retroactive is a matter of federal law. And whatever the state Supreme Court thinks about retroactivity of a federal decision is not going to be relevant. So taking all that, what might happen to some of the questions that retroactivity of Obergefell raises? Well, the concept of the bona fide or innocent purchaser solves some of the problems. The innocent purchaser who purchased the home from the Texan married to another Texan of the same sex should be fine. Even though Obergefell is retroactive, their marriage existed from the moment it was validly celebrated. They've been accumulating community property all that time, but the purchaser has no reason either one to know they're married or to ever believe it would have any effect. Now, what happens to the proceeds, those are clearly, I think, still community property, so you're going to trace them. As far as I understand it, those of you who live in community property jurisdictions trace things all the time. That's not going to be a serious problem. What it means for Florida homestead, I wish I knew. It is a terribly complicated problem. And were I the dictator of Florida, I tell the legislature, enact a statute of repose and get this over with, with what? Within 3 years? The minute Obergefell was decided, in fact, there is still a lot of panic, I am told, among the Florida title insurance companies, as you can imagine. What it means for these presumptions of conveyances to people described as spouses or as husband and wife, the kind of thing we have in New York, again, difficult to know. When it comes to succession on death, probably not much, because the will may very well leave everything to that surviving spouse anyway. It will have an influence on basis step up, whether it really was jointly held property or not. But not such difficult a problem, I think one that's going to arise very often. Creditors might really care whether it's entirety's property or not. And again, we'll probably have a few cases that try to sort that out. When it comes to intestate succession, which is the most analogous to Trimble, again, I think for deaths with near the time Obergefell was decided, I really do think Reed v. Campbell is the answer. As long as this estate is somehow still going on, that survivor is going to be a spouse for inheritance purposes. And what that means is that the administration is just going to change. And it's all going to go to the survivor, split between the survivor and descendants of the decedent. In tested administrations, it's going to be interesting because, again, imagine our Texas couple. One of them dies shortly before Obergefell. The will leaves everything to the surviving spouse spouse, but not recognized in Texas. The family, of course, has standing, whoever the heirs might be, has standing to challenge the validity of that will, and they do so. If this case is still winding its way through the courts, at whatever state it is, on June 26th of 2015, the surviving spouse is now the surviving spouse. The marriage has existed from whenever it was celebrated, and I think that cause of action goes away. Their standing vanishes, and that will, they have no standing to challenge that will, unless they remain heirs after the spouse is recognized. Now, what open means, again, can be tough, and you wonder how far we're going to have to go to decide the state really is closed. Now, if there's been a formal probate proceeding, and if the PR has been discharged, and there's a judicial decree saying everything's over with, maybe that really is closed for these purposes. But again, as I said, many estates never reach that point. They're informally settled. The Uniform Probate Code does have a way to make sure estates are closed. It's not a provision that's been adopted everywhere. So I will probably have a certain amount of quarreling over and maybe some interesting decisions on what it means for an estate to be closed. A little more, I think, tougher in the testate situation where, let's say, that surviving spouse, not recognized under state law, the will leaves everything to that person. They have settled with their late spouse's heirs, settled their challenge to the will. If that settlement is fully executed, maybe if it's been embodied in a probate decree, maybe then there's nothing that surviving spouse can do about it, even though now retroactively the people with whom the spouse settled had no standing at all to challenge that will. There are lots and lots of cases about when you can reopen a probate decree, when you can reopen a settlement, and I think we will certainly see attempts to do that as time goes on. The question of retroactivity and dissolution, again, is perhaps somewhat the same. If community property is being accumulated ever since the marriage was validly celebrated, on dissolution, everything's community property that would have been had the state recognized the marriage from the beginning. We actually, though, have a really interesting New York case, which raises several of the issues that are certainly going to come up. It's on page 30. It's the O'Reilly-Mooreshead v. O'Reilly-Mooreshead. So here's what happens. Two women entered into a civil union in Vermont in 2003. They're residents of New York at the time. They go to Vermont. They enter the civil union. They come home to New York. In 2006, they go to Canada and marry there and return home to New York. But before that, in 2004, one of the couple, with her own funds, purchases a home and takes title in her own name. They both live there, but one of them is the record owner, and indeed the only person who contributed to the purchase. In 2011, they separate, and the spouse who purchased the home files for divorce, and the other spouse counterclaims for a dissolution of the civil union. And the question is the home marital property under New York law? Because if it is, it's subject to equitable distribution on divorce. Now, the equitable distribution laws basically say the court is to divide up the couple's property, broadly defined, in a way that is equitable. I was a baby lawyer when this became the law of New York, and we knew then exactly what would happen. This has been a bonanza for forensic accountants. When there's a lot of money involved, there's a lot of research that has to be done about what money was used to purchase what. Now, the Supreme Court in Monroe County, Rochester, which is dealing with this divorce case, first says what I think is absolutely correct under New York law. The Vermont civil union is completely irrelevant. New York never had a marriage equivalent, civil union or registered domestic partnership of any sort for same-sex couples before the Marriage Equality Act in 2011, which allowed same-sex couples to marry in New York. On the way there, we have several New York cases saying this Vermont civil unions was dealt with, but by extension, all of these marriage equivalents have no status under New York law. And if there's no status under New York law, the home acquired, why their couple was in a civil union, all of with, everyone admits, with funds belonging to only one of the partners, clearly cannot be marital property subject to equitable distribution because it was not acquired during marriage. The court does say, however, and the home-owning spouse concedes in her papers, that if she had acquired the house after the 2006 Canadian marriage, it would be marital property. And that's really interesting because New York doesn't recognize validly celebrated same-sex marriages until 2008. So it seems to say, what this decision seems to say, is that, yes, recognition can be retroactive. So long as the marriage was validly celebrated, once the state recognizes same-sex marriage, either because it did it through its own processes or because of Obergefell, the marriage goes back to when it was celebrated. Now, this does raise another issue, which is the question of the various marriage substitutes. The civil unions, the registered domestic partnerships, which are sort of the way station on the way to same-sex marriage. The federal government still, with one great exception, refuses to recognize them based on language in Windsor. And there's language in the outline about the latest pronouncement from Treasury, some proposed regs about why they don't want to recognize these marriage equivalents. There are lots of interesting subsidiary questions here. At the beginning of the outline, there's a listing of all the states that went from legislated marriage equivalents to legislated same-sex marriage and the various transitional rules they did, which are important then for telling you when the marriage began, for whatever purpose you're trying to investigate that. The one great exception is Social Security. In, I guess, the spring of 2014, the Social Security Administration, which had been operating on a place of residence rule, which meant when you filed for Social Security benefits as a spouse, the determining thing was whether or not the person whose Social Security record you were filing on, the so-called number holder, whether that person resided in a state that recognized your marriage. In June of 14, the Social Security Administration said, you know, we're going to recognize all these non-marriage legal relationships as the equivalent of marriage, so long as they give the people who are in them the same rights to inherit from each other in intestacy as spouses have. This fits right in with what the Social Security statute describes as what makes a family relationship. It's all based on inheritance rights. The other thing that's interesting for Social Security, and I'll end here, I think, is that what about retroactivity for federal purposes? Well, the Treasury got away easily with this because after Windsor it said, yeah, you know, we'll recognize your marriage whenever it happened, but you're not going to be able to get refunds or file new returns beyond the usual 3-year period for filing an amended return unless you filed some sort of protective election. That's not many people did that. The Social Security Administration, though, has found itself in a bind because now, after Obergefell, what about those people who claim Social Security benefits as spouses but were denied because they were living in a state that didn't recognize their marriage or never applied at all because they figured it was futile? Well, the outline mentions settlement of a case in Illinois brought by Lambda Legal Defense in which the Justice Department conceded that we'll recognize the marriage from the beginning, even though they were resident in a state that did not recognize it. And just on Tuesday, we got the same result in a case in Florida brought by the surviving spouse of a same-sex marriage whose spouse died and whose claim was made for Social Security benefits before Florida recognized same-sex marriage. It seems that the Social Security Administration is moving towards a retroactive recognition of marriage, at least where there was a claim made for benefits at the time Obergefell was decided, or the claim had been denied and an appeal was made, so long as the issue was still alive and there was a claim on which you could collect. This fits with the way Social Security has long addressed these issues, which is when the law changes, the new law applies to people who have made claims for benefits, even though they were denied under the old law. Because as far as Social Security is concerned, everything starts when you make your claim. And it's true that the Social Security Administration, ever since Windsor, has been advising same-sex couples, if you have any thought at all that you have a claim for Social Security benefit based on the fact you're married to someone of the same sex, make your claim. And their official instruction to all Social Security field offices is that you should now begin to process all those claims we held, waiting for things to get resolved. Because now, of course, so long as the couple was validly married sometime, doesn't matter where they lived, when the claim for Social Security benefits was made. So I think the bottom line is, for all the talk that's gone on, Obergefell is retroactive. The effect of it will be tempered by what I have to call the common sense of our legal system, like bona fide purchasers. No one's going to be able to disavow the transaction they made. No one's title of real property is going to be called into question because now something that was legally impossible at the time they took that deed, at the time they purchased, now is possible. There will be really interesting questions about testate and intestate estates where death of one of the spouses occurred, however you want to define, shortly before Obergefell. And in some instances, maybe as far back as 2004, the first time valid marriages could be contracted. And it would make sense, at least for states, I think particularly Florida with these homestead problems, to look back to what happened under Trimble v. Gordon to find some legislative solution like a statute of repose. So at least the questions work themselves out in a limited number of years. Now, it would not be right for me not to close by saying, I've always loved coming here to speak, but this time is particularly wonderful because today I'm as married in Texas as I am at home in New York. Thank you.
Thank you so much, Professor LaPiana. Our next and final speaker of the day is Mr. Jared Walker. Jared was born and raised in Clyde, Texas. He's a graduate of Angeles State University, where he double majored in physics and mathematics. Jared is currently a second-year JD MEN, which is Masters of Engineering, dual degree student here at Texas Tech School of Law and the Edward E. Whitaker Jr. College of Engineering. Jared serves as a staff editor for our journal and is a member of the Texas Tech Intellectual Property Club. Jared also was in charge and very, very helpful in doing today's sound, PowerPoint, anything with respect to the electronics, which without him, we could not have made it through this day. Jared will be presenting his article published, or to be published in Volume 8, Book 2 of our journal, and entitled, we'll be presenting on that today, which is entitled Return of the UFADAA, How Texas and Other States' Adoption of the RUFADAA Can Change the Internet. Please join me in welcoming Jared to the stage.
Okay, can you hear me? Okay. First off, I'm going to have a lot of acronyms, so I'm going to apologize for that. So if you hear me say the word UFADAA or RUFADAA, we're referring to these acts. The great thing that is going on today about the UFADAA and the RUFADAA is that we are now discussing our legal rights to digital assets. Now, the UFADAA, which is the Uniform Fiduciary Access to Digital Assets Act, and the RUFADAA, which is the revised act, make great additions to our legal aspects of gaining access. Now, the reason I continue to say access is these laws don't go far enough because they don't actually give us the right to transfer certain digital assets. But since the beginning in 1991 with the first public internet, digital assets have always been and will always be a part of our lives. Now, there are three main types of digital assets. There are textual content, which are basically emails, Word documents, things without images or moving images or sound. Then we have our images. Now, we have Snapchat, we have Shutterfly, we have anything that saves images for our use. And our third type are multimedia type. And they take the images and either put them to sound or cause the images to be moving. Now, this isn't a large issue, but there are now sites, such as Facebook, who incorporate all three types, and so are rather hard to describe individually. They have messaging systems, they have videos, they have everything. That is actually probably the original users. Now, the UFADAA, which was originally the first attempt to gain access by fiduciaries by the National Commission, granted default access to the fiduciary. There needed to be no court order. There needed to be nothing except for a will or another type of legal document saying that they had access. Now, the real interesting thing about the UFADAA is that digital assets means a record that is electronic. This term does not include an underlying asset or liability unless the asset or liability is itself a record that is electronic. Now, that's trying to describe all those different types of digital assets as an electronic record. That's vague, but it tries to capture all those ideas. Now, Delaware, which is the only state currently to have adopted the UFADAA, took that definition and slightly broadened it to be a little more realistic and understanding. Next we have in our progression of digital assets is the Peace Act. Now, the Peace Act does not grant fiduciary access. It's actually a privacy law. And nowhere in it does it describe what a digital asset is, but it makes it to where if a fiduciary is going to have access to it, there has to be a judicial ruling saying that they have access. Vermont, it's Virginia. Virginia is the only state to currently have this on the books. And neither, to my recollection, has the UFADAA or the Peace Act been challenged judicially. Now we get to what is more current law, which is the RUFADAA. Now, just last week, rather happily, the Florida House and Senate have passed it, and it is sitting on the governor's desk. The RUFADAA takes the ideas from both acts and tries to incorporate some of the ideas that corporations have done. Now, the leading corporations in this field are Facebook and Google, who are also the funders of the Peace Act. They have helped encourage more privacy laws. Facebook implemented what they call a legacy contact, where anything on your account can be, if you choose, left to a specific individual who has a Facebook account. But they also added in a clause that allows you, upon termination of your life, to terminate the account and delete it permanently. In this doing, they have incorporated this idea into the RUFADAA, sorry about that, and have input it into the three-phase process, which is the first phase of using an online tool. And using that online tool to delegate which fiduciary has right to your account or the deletion of that account. Now, the second phase, which is also very traditional, is to follow a will or a legal document. Now, we all know how that works, and it's very straightforward. Now, you may need a judicial ruling to gain more access to the account, but in the current state, let's say for a conservatorship, a conservator wanting access to an email account may be able to show to the custodian express consent from a user. So that would be the will or an online tool. But if the conservator doesn't have either one of those claiming, but has some other documentation, they can gain access with good cause. So this allows them to be more effective in representing their client's desires. The third method is to follow the terms of service, which is the little click wrap agreement that you click on with every digital asset you ever have thought of using. Now, it's been argued that if you encourage more users to dictate what they want, you will have happier customers. And that is why Google and Facebook have been so progressive in trying to make the user happy. Now, there are some federal issues with all this, and some of them are rather old and out of date. We have HIPAA, which is a relatively young law still. We have the Digital Millennium Copyright Act, which is considerably young still. But you get to the Stored Communication Act and the Computer Fraud Abuse Act, and they have remnants of the law that were before the internet existed, really. It's still based off ideas that were in the intranet of the Pentagon. And it hasn't caught up with the times of transferring assets to no longer being physical to them being just digital. Now, the last one on this list is the Americans Inventors Act. And you can include this for the reason of it blocks transferability a lot of the times, because the code itself on the software that is your digital asset, you have no legal right to. You might have a right to the digital asset, but you don't have a right to the code of the digital asset. So it's a separation of the issues that can be caused. Now, Professor Beyer, who is one of the greatest experts on this field, I've talked to him hours on this, suggests 7 things to do with your clients. Now, the first thing is use the company's online tool if they offer it, which if the RUFADAA is adopted in more states, it will be a very useful tool. The second way is to back up your usernames, accounts, and other things in tangible medium, so USB drives, things like that. Now, he warns that the FCAA may be violated, so you have to make sure your client is storing it in a proper way. Specifically, encryption is important so that no one besides the original user, because when you sign up for the account, you agree that you're not giving your account out to other people. Third, keep a comprehensive list of your digital assets and a ledger. Okay, this is probably one of the more dangerous ideas, especially because of identity theft and because of the 2 federal laws that say don't give out your account information. Fourth way is to give access to your digital estate to someone now. That also has the issue of when you sign up for it, the terms of service is for 1 user. The fifth way of granting an agent the ability to access your digital assets in certain situations on your behalf, this works really well with the RUFADAA and the UFADAA if your client is currently incapacitated or has become deceased, it still will fall into both of those laws and follow the progression. The sixth way is to create a digital asset trust. This is a new idea. It's been around for a couple of years. It is like saying that you never die. Your trust continues, it buys all the digital assets, and thus the terms of services do not cause the termination on death of one of the participants. Seventh way is to write a will leaving your digital assets to someone else. And the eighth way is to use an online afterlife company. Now, these companies are relatively young, they are untested, and we don't know how long they will sustain on the market. It's always advised to do good research and be proactive. My suggestions is we need to update the federal laws to encourage not only access to your digital assets, but transferability. I would suggest creating an equivalence between real assets and digital assets and enforcing companies to treat their materials as equivalents. Thank you.
Thank you so much, Jared. Well, everybody, that concludes our presentations for the day. We are so happy that we had so many amazing speakers and presentations for you all, and hope that you can take back some wonderful notes to your practices.
I just wanted to say again, thank you guys so much for being here. This ended up being such a wonderful event, and like Ashley said, I hope that you took something away from it. We have a tremendous amount of snacks left, so please take some home to your kids, to your wife, take some home for you, like 8 things home for you. But thank you for being here, and we hope to see you again next year.